Hello students and welcome to EPG Pathshala. I am Dr. Vageshwari Deswal, teaching at Faculty of Law, University of Delhi. Today we will be discussing the module Categorization of Rapes under the Indian Law. This is the second module on the topic of rape. In the first one, we discussed the substantive as well as the procedural law relating to rape and rape victims in our country. These modules are a part of the paper Women and the Law for the subject Women Studies. The objectives of this module are: first, to understand the difference between the term rape and sexual assault, and secondly, to understand the various categories of rapes recognized under Indian laws and the punishments prescribed for them. So broadly speaking, we have the following categories of rapes under Indian laws. The first category is statutory rape, then marital rape, then there is custodial rape, then we have gang rape, brutal rape, digital rape and incestuous rape. The first category of rape that we will discuss today is statutory rape. Having sexual intercourse with a minor, that is a person below 18 years of age, is known as statutory rape. Why it is known as statutory rape is because clause 6th of section 375 provides that in rape cases, the consent of minor is immaterial and inconsequential. Thus, whosoever establishes sexual relations with a minor would be guilty of statutory rape. Earlier, the age of consent was 16 years. But after the Criminal Laws Amendment Act of 2013, now this has been raised to 18 years. Under the POCSO Act also, which is Protection of Children Against Sexual Offences Act, boys below age of 18 years are also protected against sexual assault. The Criminal Laws Amendment Act of the year 2018 has enhanced the minimum sentence for offence of rape against girl child. Under the new law, if the victim is below 12 years of age, the culprit faces minimum sentence of 20 years and the maximum punishment is death penalty. In cases of gang rape of a child below 12 years of age, the minimum punishment is life sentence while the maximum is death penalty. In cases of child aged between 12 and 16, the offence of rape is punishable with a minimum sentence of 20 years. Maximum punishment in such cases is life imprisonment. If a girl is aged between 12 and 16 years, and if she is gang raped, then the convict faces minimum punishment of life sentence. If the victim is aged between 16 and 18, the offence of rape is punishable with minimum punishment of 10-year jail term and maximum is life imprisonment. Repeat offenders will be punished with life imprisonment or death. The Act provides for time-bound investigation in cases of rape of girl children. The investigation into rape of a child must be necessarily completed within a period of 2 months. The case is to be tried in a fast-track court. The Act states that any appeal against a sentence by the trial court must be disposed of within 6 months. The accused is not entitled to anticipatory bail under the new law in offences of rape of child below 16 years of age. The Protection of Children from Sexual Offences Act, which is known as the POCSO Act, was formulated in the year 2012 in order to effectively address sexual abuse and sexual exploitation of children. The Act defines a child as any person, whether a male child or a female child, any person below 18 years of age. So this is a gender-neutral law in which both the perpetrator of abuse as well as the victim of abuse can belong to any gender. This is the reason that the Act uses the term sexual assault instead of rape. The term sexual assault is gender neutral in nature, whereas the term rape is gender specific. Rape can be committed only against a woman. POCSO defines different forms of sexual abuse, including penetrative and non-penetrative assault, as well as sexual harassment and pornography. It deems a sexual assault to be aggravated under certain circumstances, such as when the abused child is mentally ill, or when the abuse is committed by a person in a position of trust or authority like a family member, police officer, teacher, or doctor. So, in cases where the protector turns perpetrator, then a higher punishment has been prescribed. Non-reporting of sexual assault on minors is an extremely disturbing trend in our society, possibly due to the lack of clear-cut legislative provision casting an obligation on them to report to the Juvenile Justice Board or to the Special Juvenile Police Unit dealing with sexual offences towards children after having witnessed the incident. After the enactment of POCSO, which is the Protection of Children Against Sexual Offences Act of the year 2012, now reporting of sexual offences against children has been made mandatory. This act casts a legal duty upon a person who has knowledge that a child has been sexually abused to report the offence. If he fails to do so, he may be punished with 6 months imprisonment and or a fine. So you see, now reporting of incidents of child sexual abuse is not only a moral obligation, it has been now made a legal duty, the non-performance of which is punishable under the law. Child rape needs to stop. Incestuous rape. Now, incest is defined commonly as the crime of establishing sexual relations between a male and female who are so closely linked by blood or affinity that such an activity between them is forbidden by law. Now, rape and incest are separate offences because we had already clarified in the earlier module that rape is a question of law. Incest could be consensual as well. So, rape and incest are separate offences and are distinguished by the fact that mutual consent is required for incest but not for rape. When the female is below the age of consent, as recognized by the law, however, the same act can be both rape and incest. In the case of Lokesh Mishra versus State of National Capital Territory of Delhi, the Delhi High Court expressed deep anguish over such matters and stated, "It shakes the insight of a woman who once was a happy person and had no clue of being a victim of the said horrifying and nightmarish encounters, where the daughter had been raped by none else but her own father. A daughter always looks up to her father as a shield of her dignity and honor, which is an intrinsic facet of a family, especially of a father-daughter relationship. It shocks human conscience when the sanctity of father and daughter relationship is ravaged in such a sordid manner and the protector becomes the violator. In such a case, the offence assumes a greater degree of vulnerability which should not go unpunished. There can never be a graver heinous crime than the father being charged of raping his own daughter. It is the gravest sin where the most platonic relationship is shattered by an extreme, pervert and shameful act of none else but one's own father. The moral values of individuals of the society have gone down to such a level that every day we hear similar news which shudders our mind and soul. We have become accustomed to saying that females are not safe outside the house. But in a few cases it is seen that they are not even safe inside their homes, where the epitome of God's beautiful creation, a child is ravished by her own father for his momentary sexual needs and pleasure, which is heart-rending and odious. Brutal rape. Now, what amounts to brutal rape? Section 376 2M and Section 376A prescribe higher punishments for rapes that are committed in a brutal manner, such as leading to grievous bodily harm or injuries that maim or disfigure or endanger the life of a woman. Thus, rapes which cause the woman to die or be in a persistent vegetative state have been made punishable with rigorous imprisonment for a minimum term of 20 years, which may also extend to imprisonment for life, and in extreme cases, the penalty of death may be awarded. Whenever we talk about brutal rapes, the case that comes to our mind is that of Aruna Schonborg. Aruna Ramchandra Schonborg was a staff nurse working in King Edward Memorial Hospital, Parel, Mumbai. On the evening of 27th November 1973, she was attacked by a sweeper in the hospital who wrapped a dog chain around her neck and yanked her back with it. He tried to rape her, but finding that she was menstruating, he sodomized her. To immobilize her during this act, he twisted the chain around her neck. The next day, a cleaner found her in an unconscious condition, lying on the floor with blood all over. It was alleged that due to strangulation by the dog chain, the supply of oxygen to the brain stopped and the brain got damaged, leaving her paralyzed. A police case was registered as a case of robbery and attempted rape and attempted murder because of the stigma associated with anal rape. Aruna at that time was engaged to be married, and the hospital administration wanted to save her impending marriage. This led to the accused's eventual conviction for robbery and attempted murder, for which he underwent 2 concurrent sentences of 7 years each and escaped the 10 years imprisonment that could have been awarded under Section 377 of the IPC. Aruna died from pneumonia on 18th May 2015 after being in a persistent vegetative state for nearly 42 years. The case sparked a public outrage, and punishment of 7 years imprisonment was considered too less a punishment for a crime of such magnitude. You can see on your screens a file picture of Aruna Schonborg. In this picture, on one side is an image which was taken before she was subjected to this crime, and the other image is a few years before her death. See what time did to her, and it was all because she was subjected to this extreme brutality in the name of rape. Next, let us try and understand that what is marital rape. Marital rape means non-consensual and unwanted sexual intercourse by a man with his wife by using physical force or threatening to use force, or under circumstances when wife is not in a position to give consent. So what constitutes marital rape under law? Sexual intercourse or sexual acts by a man with his wife below 18 years of age. This is given under exception 1 to section 375. The exception says that sexual intercourse or sexual acts by a man with his wife below 15 years of age. But recently there was a judgment given by the Supreme Court of India in November 2017, after which this age has been raised to 18 years. In November 2017, a division bench of the Supreme Court of India read down exception 2 to section 375 IPC in the case of Independent Thought versus Union of India. The Supreme Court considered international instruments to which India is a signatory, such as the Convention on the Rights of Child and the Convention for Elimination of All Forms of Discrimination Against Women. Since the marital rape exemption legitimized the practice of child marriage, it was found to be in contravention of the obligations imposed by these instruments. Secondly, the exception was found to be derogatory of Article 14 and 21 and therefore unconstitutional. Thirdly, it was observed that the exemption was inconsistent with other laws in force. And this also created internal contradictions within the IPC. Finally, it was held that the social impact of child marriage, which was legitimized by the marital rape exemption, was too great to let the exemption stand on the statute book. Punishment for marital rape is 7 years to life imprisonment, and sexual intercourse by a husband upon his wife living separately under a decree of separation or otherwise without her consent is punishable with a minimum 2 years of imprisonment, which may extend up to 7 years. Marital rape is not recognized as a crime in our country. Our lawmakers, they refuse to criminalize marital rape on the grounds that we already have laws dealing with it, as we have law for Protection of Women Against Domestic Violence Act 2005 and marital rape, that is rape or establishing sexual relations with wife against her choice, would amount to sexual violence, and if she wants, she can obtain restraining orders from the court to stop her husband from subjecting her to this kind of an abuse. And this also amounts to cruelty, physical as well as mental, under section 498 of the Indian Penal Code. Further arguments that are taken are that marital rape would be difficult to prove, but then there are so many other crimes also which are difficult to prove. Does it mean that we will decriminalize all such crimes? Another favorite argument which is advanced in such cases is that punishing a husband for marital rape would destroy the family. Little do they understand that the act which has destroyed the family is the act of the husband in forcibly raping his wife. The third argument which is given in such cases is that it would be susceptible to misuse. There are many other laws also which are capable of being misused, but that is no ground itself to stop making new laws. Now let us try and understand what is the meaning of custodial rape, in which there is an abuse of authority. The law says that rape by persons who are in a position of authority, for example, rape by public servants with women in their custody, or by police officers on any women in their custody, by superintendent of jail or remand home on any female inmate of such jail, remand home or institution, or by management of staff etc. of hospital on any woman in that hospital, or by relative, guardian or teacher of such woman, is termed custodial rape. In cases where someone forces, induces or pressurizes a woman to consent to the sexual act by use of his position or authority, then such a person will be liable for abuse of authority, which is punishable with the rigorous imprisonment ranging from a minimum of 5 years up to 10 years. Now coming to the next category of rape, which is gang rape and which has been defined under section 376D of the Indian Penal Code. The law says where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have committed the offence of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years but which may extend to life. After the 2018 amendments now, in the cases of gang rape of child below 12 years of age, the minimum punishment is life sentence while the maximum is death penalty. If a girl is aged between 12 and 16 and she is gang raped, then the convict faces a minimum punishment of life sentence. Gang rape implies rape of a woman by more than one person forming a group of people acting in furtherance of their common intention to commit rape on such woman. Common intention, as mentioned under section 34 of the Indian Penal Code, implies a prior meeting of minds, that is, an agreement, whether express or implied, among the accused persons to do some act. In cases of gang rape, every person forming a part of the group having common intention to commit rape would be held guilty irrespective of whether he commits the sexual act individually or not. In cases of gang rape, the proof of completed act of rape by each accused on the victim is not required. However, a measure of jointness in action and forming of a single group is essential. It was held by the Supreme Court of India in the case of Ashok Kumar versus State of Haryana in the year 2003 that in order to establish an offence under section 376 clause 2 subclause G, the law as it was then, read with explanation 1 thereto, the prosecution must adduce evidence to indicate that more than one accused had acted in concert, and in such an event, if rape had been committed by even one, all the accused will be guilty, irrespective of the fact that she had been raped by one or more of them. And it is not necessary for the prosecution to adduce evidence of a completed act of rape by each one of the accused. In other words, this prosecution embodies a principle of joint liability. And the essence of that liability is the existence of common intention. That common intention presupposes prior concert, which may be determined from the conduct of offenders revealed during the course of action, and it could arise and be formed suddenly. But there must be a meeting of minds. It is not enough to have the same intention independently of each of the offender. In such cases, there must be criminal sharing marking out a certain measure of jointness in the commission of offence. The person acting in a group in furtherance of their common intention is distinguishable from several persons coming with the similar intention of having sexual intercourse with a girl individually. Earlier, it required presence of common intent for conviction in cases of gang rape. But now, after the changes introduced by the 2013 amendment, if the accused is a part of a group of persons, some of whom commit rape and others do not, still all the members of the group shall be deemed to have committed the offence. Another important change that has been brought about by this is relating to a question which would be often raised, which is, can a woman be held guilty of gang rape? Earlier we had a judgment which was given by the Supreme Court in the case of Priya Patel, in which the court ruled that a woman can never have the intent of committing rape on another woman, because that is something which is physiologically impracticable. So the court said that since a woman cannot have the intent of raping another woman, so she cannot share this common intention with other accused persons, and therefore a woman cannot be held guilty of raping another woman. But now, post 2013 amendments, what has been changed in the law is that it is not only common intention which is required. Now the law says if there is a group of persons also who have committed gang rape on a woman, that is, some persons out of that group, they have committed rape and others have not committed rape. But the essence of affixation of liability here is that those persons, they must have acted in a group. So now a woman, she can be a part of the group from which some people commit rape and others they do not. So now even women can be held guilty of gang rape. Now coming to the next category of rape, which is digital rape. So digital rape refers to the manual manipulation of female genitals by the use of fingers, sticks, bottles, objects, etc. Now this kind of rape is very common in cases of child abuse. Earlier, it was not covered under the definition of rape. Now, that is after 2013 amendments in the criminal law, digital rape has also been made punishable under the law. Now there are some additional categories also, such as rape by armed forces personnel in areas where they are deployed on duty. This is covered under section 376 clause 2 subclause C of the Indian Penal Code. Now this is a law which is related to protection to acts which are done by such public servants in the course of performance of their duties. For example, if during pursuit of a criminal, they enter someone else's property without their permission, it would ideally amount to trespass. If they destroy someone's property in the pursuit of a criminal, that would amount to mischief. Now there is a protection which is given to armed forces personnel when they are deployed on duty or when they are acting in the course of their duties, because they need this kind of a protection, and so in such cases we need a prior sanction of the state before prosecuting them. But where such armed forces personnel, they commit rapes, then no sanction is required, because rape by no stretch of imagination can be said to have been committed in the course of performance of their duties so as to entitle them to any kind of protection. Then the next category is rapes committed during communal or sectarian violence. So if anyone tries to take advantage of the unrest in a situation and commits rapes during the communal violence or sectarian violence to take advantage of the situation, then that is also made punishable. Rapes on pregnant women have been made separately punishable. Similarly, raping a woman who is suffering from mental or physical disability has been made punishable under section 376(2)(I). Repeatedly raping the same woman is punishable. Then raping a woman incapable of giving consent has also been made specifically punishable. Attempt to commit rape. C. Attempts towards the commission of a crime are also punishable under the law. An act which is capable of translating into the forbidden consequences sometimes falls short of the completion of the crime on account of certain supervening circumstances. The accused is nonetheless to be punished for attempting the commission of such a crime. Thus, attempt to commit a crime is also a crime, and attempt to commit rape is also punishable under the law. In the end, I would just like to say that rape is the most horrific of all crimes committed against humanity. It degrades the human to a commodity who is ravished against their wishes. The beautiful act of making love has been distorted to an extent where one shudders and shivers at the mere thought of the brutality associated with rape. Our lawmakers have tried to cover all sorts of sexual violations of a woman by comprehensively drafting the laws and making different categories of rapes punishable heavily. So, we can say that we have the laws in place. Now, what we need is the proper implementation of these laws by all the stakeholders. Thank you.